Okay, good evening. Welcome to International Commercial Arbitration. I hope the microphone works very well, that everyone hears me. So my name is Juan Kidani. I'm visiting from Seattle University Law School. And I'm teaching this class this term. As you all know, we have about 15 classes together. It's a very intense one. And the textbook that we're using is Gary Bourne's Commercial Arbitration Basics and Materials. So we'll go over that textbook methodically, step by step. I'm sure you've gotten the syllabus. And I expect you to read the assignments for each class before you come to class. Each class is 2 hours long. We will take approximately 10 minutes break in between. What we're going to do today is try to justify why we are studying commercial arbitration. As you all know, commercial arbitration is an alternative form of dispute settlement. So if arbitration is an alternative form of dispute settlement, what is the main form of dispute settlement? So that would be the first question, right? What is the main form of dispute settlement?
Litigation.
Litigation, right? So what is it about litigation that we don't like that would lead us to embrace commercial arbitration? Why do you need alternative to the main form of dispute settlement? So that's what we're going to be considering today. That's why I call this class the challenges of transnational litigation. When litigation is purely domestic, the jurisdictional complications are limited. There's always jurisdictional complications anywhere in the world, right? If you live in Shenzhen and someone sues you in Beijing, what would be your objection to jurisdiction? And I'm assuming, are you taking or are you taken civil procedure? You are taking it now? You're studying jurisdiction, right? Have you studied personal jurisdiction?
Yes.
You're studying personal jurisdiction. So if you live here and someone sues you in Beijing, you appear before the court there, and if you have no residency in Beijing, you would appear before the court and say what to the court?
No jurisdiction.
Exactly. So you would just simply say, the court does not have jurisdiction, personal jurisdiction, meaning jurisdiction over your person because you don't reside in that district or in that city. Imagine if you were sued in London. You don't even live in London. So if someone, for some reason, sues you in London, you have two options, right? One option is what?
Go to the court and argue no jurisdiction.
Yes. One option, obviously, is to go to court and tell the court that it does not have jurisdiction. What's the second option?
Get along, yeah.
Sit at home, and maybe the judgment from London has to be enforced in your country. You will just appear in your country and say that there is no jurisdiction against you.
Yes. But what happens if you fail to appear before the court? If you just ignore the summons? You know what summons are?
Before
Georgia.
Exactly. So if you just completely ignore it, what would happen? Maybe. That's right. The court might enter a default judgment because you have not appeared before the court to dispute jurisdiction. So it's always very prudent to appear before the court and say that the court does not have jurisdiction. But that involves a lot of traveling, cost, hiring attorneys, and things like that. So now, today, we're going to look at jurisdictional issues jurisdiction to adjudicate in comparative context, that is what you see there, service of process and evidence located abroad, enforcement of foreign court judgments. So this is the outline of what we're going to be discussing the first half of this class. Second half, we will try to introduce commercial arbitration generally. Okay? Now, the jurisdiction that you're familiar with, the jurisdiction that you study in your civil procedure class, is called jurisdiction to adjudicate. It must be distinguished from jurisdiction to prescribe. I'll say a few words about that. I don't know if you've heard of it. Jurisdiction to prescribe. We're not going to study that, but I think you need to know what it means because it helps you distinguish jurisdiction to adjudicate. That's the court's power to adjudicate controversies that is presented before it. Jurisdiction to prescribe is prescribed like in medicine. When a medicine is prescribed to you, the doctor is ordering you to take certain medicine, right? Jurisdiction to prescribe is the jurisdiction to make laws, to make rules. The jurisdiction is territorial in a way. If, for instance, the Chinese Congress, Council, people's representatives, the lawmaker, makes laws, and those laws are supposed to be implemented where? Can the Congress make laws that apply in other countries?
No.
So it is that jurisdiction to prescribe is limited to its own territorial jurisdiction. That is, the jurisdiction of one country to make laws is limited to its own territory. Sometimes, some states, some lawmakers may have jurisdiction to prescribe rules that apply outside of their country. Ordinarily, those laws pertain to the Chinese government the lawmaker makes laws that apply outside of China. They may concern what? Maybe Chinese citizens, right? If you're traveling abroad, your own government may have the power to regulate your conduct while you're away. So that is also called jurisdiction to prescribe. It's the power of that state to make laws within its own country and outside of its country affecting its own nationals. So that concept of jurisdiction must be distinguished from what we're going to be studying today, which is jurisdiction to adjudicate, meaning to decide cases. And then, if you sue someone, the first thing that you must do once you file the case is to inform that individual that she is being sued. Right? That's very basic service of process. Unless the person knows that that person has been sued, the court would not have jurisdiction. They would tell you, okay, inform that individual that you are suing that individual. And the way you inform that person, you can't just email the complaint, you can't just reach out that person. There is a formal channel through which service of process is presented. If that person is in another country, in London, there are complications. You can't just mail a copy of it because it's an official act that needs to go through certain protocols, procedures. So that is what is called service of process. And evidence located abroad. Imagine you are initiating a lawsuit here. Let's say you're suing the telephone company Huawei. And then the evidence that you want to present to court is actually located in London. You need to present that to this court. How do you do that? That's also a complication that we're going to be looking at. Assume that you have won your lawsuit here, but the person that you sued does not have anything in this area or even in China. Let's assume further that that person has a lot of property in London. What do? You probably take the award or the judgment, the court judgment, to London and ask the court there to attach the property and satisfy the judgment. All of these things have their own complications. So imagine what we're trying to do is show why commercial arbitration helps us avoid all of these jurisdictional complications. Jurisdiction to adjudicate. Whether or not a court has jurisdiction over a particular subject matter and over a particular set of parties is always a question of law. You need to find some law to tell you whether the court has jurisdiction or not. Without a particular set of laws, you will not be able to know whether a court has jurisdiction or not. So what are the sources of law? Have you studied international law or have you taken international law? Any courses? Public international law? Okay, let me introduce the concept of sources of law. Every time you are confronted with a legal problem, every time you're asked a legal question, the first question that you must ask yourself is, what is the law that tells me the answer? That is what is called the source of law. Where do I get the law from to answer this question? So when you are asked, does the court have jurisdiction? The first question that you should ask is, what law applies to tell me whether the court has jurisdiction or not? What is the source of law? Where does it come from? Many countries, I believe including China, have jurisdictional statutes, law that the lawmaker has made, describing the jurisdiction of courts. So if you have that piece of law, no problem. Just refer to that law and see if that particular court has jurisdiction to adjudicate that particular dispute and has jurisdiction over the particular parties. Right? So this is the court. There are parties appearing before it, and they're disputing about X. The court needs to have jurisdiction over A, party A, over party B. That is called personal jurisdiction. And there is a dispute between the two. It could be a breach of contract claim. That is what is designated as X. That is the subject matter jurisdiction. Whether that particular court has jurisdiction over breach of contract claim. If it is tax court, it wouldn't have jurisdiction over contract, breach of contract, right? So jurisdiction, the court has jurisdiction over A and B relating to the breach of contract claim. Where do you find the answer to this question? There is, in many countries, a jurisdictional statute that actually defines the jurisdiction of this particular court. This could be district court, could be appeals court, this could be the Supreme People's Court. So that is the source of law where you find jurisdictional statutes. In the United States, there is no jurisdictional statute. Jurisdiction, of course, is a matter of constitutional law, particularly a concept called due process. You might be studying constitutional law, U.S. constitutional, you study that, right? So the concept of due process is simple in relation to jurisdiction. If you are in Xinjiang and somebody sues you in London, if you apply the United States due process concept, it simply means it's not fair for someone here to be sued in London. Unless that person does something in London, like having business, home, studying, visiting, you need to have some kind of connection with London for you to be able to be held before the court. So in many other cases in common law jurisdictions, and I'm sure you know the distinction between common law and civil law. You studied United States, United Kingdom, Australia, common law jurisdictions, and of course China is civil laws jurisdiction with its own characters. But in common law jurisdiction, there are cases that tell you the jurisdiction of courts. And in other continental countries, there are codes of civil procedure that define jurisdiction of courts. Let's talk a little bit about service of process. So the first thing that you need to do, as I said earlier, is to actually inform the person that the person is sued. Service of process, summons, wherever that person might have been, that he or she needs to be informed that a lawsuit is pending. In the old days, what happens is the following. It's a very long process. You sue the person here. Let's say this guy is in London. This guy is in Beijing. When this person files a case with the court would give them the summons, the service, that says, oh, Mr. B, you are sued. You should appear on April 25 at such and such date and answer the charges. You cannot just make a copy and email it to this guy, scan it and email it. That's not an official act. The court would not be okay with that. So what do you do? Traditionally, there is this guild called letters rogatory. What it means is you have to go to the Ministry of Foreign Affairs and then to the embassy of this person's residence. And the embassy would forward it to his country's Foreign Affairs Ministry and the Foreign Affairs to the court. That is a very long process before this guy is served. It could take 6 months, a year, or even more, just to inform him that he is sued. That is service of process. The Hague Service of Process Convention cuts down that process, but the process still exists. It's a 1965 convention that is a treaty between many states. And the same thing for evidence. If the evidence is located abroad, you have to go through all that process before you can claim. In arbitration, you don't have to worry about all that. Because it's an agreement, you don't have to worry about service of process for a ministry, court, things like that. You can just copy the complaint, email it to him, he will show up if he is agreed. Very briefly, jurisdictional concepts in the United States. If someone sues you in Seattle, Washington, you hear about it, and you go there and dispute the charges. You appear before the court and tell the judge that, Your Honor, I'm not at fault. This person who's suing me, he's lying. It's not true. If you say that, if you appear before the court and say that, would the court have jurisdiction over you?
Yes.
Why? Because?
Consent.
Exactly. You consented to it. You cannot dispute that afterwards. And secondly, there's this concept of minimum contacts. Have you studied it? Civil procedure? Yes, very good. So if you can establish minimum contacts, whether in rem, quasi in rem, or whatever it is, conducting business, owning business, traveling here, then the court would have jurisdiction over you. The most important case is the 1945 case of International Shoes. And there's these, you will study, or you might have studied these cases also in your civil procedure class. Asahi, you studied Asahi. Yes. So this is just a reminder of jurisdictional complications. International arbitration professors like to talk about this because to show you how complicated jurisdiction could be and why we need to study arbitration that actually essentially bypasses all of these challenges. I don't think you've studied European Union law on jurisdiction, have you? It's mainly US, right? Okay, briefly. In the European Union, most jurisdictions, except the United Kingdom, are civil law. They have their own domestic codes of civil procedure. That's the source of law that tells you which court has what jurisdiction. There's also the Brussels Convention on Jurisdiction and Recognition of Court Judgment. It tells you which country has what jurisdiction, and if there is a judgment, a final judgment, how those judgments are enforced from Geneva to Brussels and things like that. The convention was signed in 1973, and it does all of these things. It's a self-executing treaty. Do you know what a self-executing treaty is? Let me explain. A treaty is what? It's an agreement among states, between or among states. If a treaty is called self-executing, that means the treaty itself is law within each one of those countries, without there being a need for making new laws to incorporate it into the domestic system. If there is a treaty binding A, B, C, D, E, and G, these are countries. They are entering into a contract saying that we shall implement the same policies domestically. If the treaty is self-executing, that treaty itself becomes law, domestic law, within each one of these countries. If it is not as self-executing, it requires each one of these to enact separate laws incorporating the principles of the treaty into the domestic system. So that is the distinction. Now, the Brussels Convention about jurisdiction and enforcement of court judgments is a self-executing treaty. That means once a European country has signed it, they're bound by it, and the courts can cite it directly for jurisdictional purposes. So it deals with jurisdiction and enforcement of foreign judgments, meaning that if you get an award, a judgment in state B, if you court a judgment in state A, court judgment in state A awarding you $100 million, and the debtor, the person who lost, does not have anything in state A, you can take that judgment to state B and ask the courts of state B to enforce it, meaning to attach property and satisfy you. That is a very important treaty. No one else has that kind of treaty. Only the Europeans, to my knowledge, at a broader scale. There might be bilateral enforcement treaties. I don't know how many China has. I know the United States does not have a single court judgment enforcement treaty. Meaning that if you get a court judgment in the United States, the district court in the District of Columbia awards you $100 million, and the guy has nothing in the United States. And you know he has $1 billion worth of property in China. To get it enforced in China could be a serious challenge. You may not be able to succeed. It could just be a win on paper without that treaty. The Europeans have figured it out, and they can enforce their own court judgments across jurisdictions. If you get an arbitral award, we will study the New York Convention. That's the most important instrument. You may be able to the award made in New York enforced in Beijing, because the United States and China are both parties to the New York Convention. So in a way, international arbitration has a superior legal framework than court judgments. You might find this surprising, but for some reason, it's complicated jurisdictional, political, and other reasons. The community of nations were able to agree for the cross-border enforcement of awards, arbitral awards, rather than the enforcement of their own respective court judgments. Why do you think that the United States would be hesitant to enforce a judgment made in Beijing by a court in Beijing, or even approved by the Supreme Court? It's reluctant to enforce that, but it would have no difficulty enforcing an arbitral award made in Beijing. That's an interesting question. But the reality is, yes, under the New York Convention, the court judgment is not enforceable, but the arbitral award is actually enforceable. But in the European Union, both are treated the same. Court judgments are easy to enforce within the European Union. So if there is a court in Geneva making a judgment, it's easy to enforce it in Brussels, in or Amsterdam or London. So there are some jurisdictional issues there, but I want you to take a look at this. Article 6 of the Brussels Convention says a person domiciled in a contracting state may also be sued where he is one of a number of defendants in the courts for the place where any one of them is domiciled, the third party in action, warranty, insurance. So this is who may be sued where, right? Take a look at this question and tell me the answer based on the previous provision. So it's this one. A Frenchman, F, is driving in France with a passenger, A. They collide with an Italian bus, B. If you are advising A, who do you want to sue and where? And I'll bring it back. Here is the rule.